We are honored to have lead these discussions licensed attorney and professional fiduciary Darby Jones, a member of the Florida and Maryland Bar. Darby serves on the executive council of the Real Property Probate Trust Law section of the Florida Bar and is a registered professional guardian. Darby is also the founder and executive director of the Professional Fiduciary Council of Florida. Planning for your future and navigating those decisions is why we're all here. Darby, can you help us understand what is a trust and do we really need one?
I'm going to help you understand. There is a lot to talk about today. I know I've said many, many times in my presentations that, what you need is just a simple estate plan, and we go through the documents and I try to make them as simply understood as possible because it is important to understand these documents. And today we are taking on one of the most challenging documents. So don't be upset if you leave today with a little bit of exploding brain problem, but I can be reached for any time with questions or follow-up. I'm happy to do that. But I'm going to do my very best to break this down into basic concepts and to give you an idea of what trusts are all about, why you may need one, why you may not need one, what they do, what they don't do. I also want to take a minute, of course, and thank Aging Academy, to thank the AARP for sponsoring us and allowing us this opportunity to reach out to so many people and build such a great community. I thoroughly enjoy it, and I appreciate all of you being here today and in future episodes. And if anybody does need to go back and look at previous episodes, you can find them in two ways. One, you can go to the website, agingacademy.com, or you can go to YouTube to Aging Academy. Just search for Aging Academy on YouTube. You can find all the previous episodes there. And please make comments and respond and give me ideas and feedback for future episodes. I really appreciate it. And I may need to do another one on trust, and I'm happy to do that if you all feel like it would be important. So what are trusts? How or why are they needed? And do I really need one? Hopefully, we're going to be able to answer those questions. I do want to also emphasize that I am not giving you legal advice here today. I'm not here as an estate planning attorney or giving any personal direction or advice. Everyone's situation is different. Every family situation, dynamics, finances, tax situation, state law, etc., is very different. So please don't take what I'm saying today as it may be 100% applicable to your situation. I'm really just trying to educate you as to the world of trusts so that you can make an educated decision yourself with your estate planning attorney as to whether they are an appropriate tool for your family or not. So trusts have been around since Roman times. They provided an opportunity or a vehicle to govern ownership of an asset, real estate, land, the castle, the dragon, whoever it is, and transfer that asset rather than relying on just the laws of the land or heirship or the culture or customs of that place. So they write it's like a contract. They write it in writing to say, I'm creating this entity, and this entity is going to control this asset. Long time ago, that's pretty much what the focus was. But if you fast forward to today, trusts have really become very mainstream. There's a lot of media, a lot of chatter and conversation about trusts and that you should have a trust to achieve all these goals. And we're going to talk about what those are. And I think a lot of attorneys have encouraged people to use trust because I think, and I don't mean this in a negative way, but obviously they're going to make more money off doing a more elaborate estate plan, which would include a trust, rather than doing a simple estate plan. So sometimes you just have to be careful about who or what the motivation is behind talking to you about a trust and whether you really, really need it or not. Obviously, there are pros and cons to trusts. And And don't get me wrong, there are a lot of good things about trust, but today I'm going to help you understand whether you really do need them or not. Trusts are like a contract. You're contracting with yourself. You're creating an entity. It's almost like you're creating a business. The Darby Jones Revocable Trust. I'm creating a business. I'm naming myself as president of that business. I'm the trustee. I've started this business. I've created this entity. I can put things into that trust or that entity, that business, or I can take things out. As long as I'm competent, over 18, I'm capable of managing my affairs, I can add to that trust, take it out, terminate it, cancel it, amend it, anything. I'm in control of that entity. But what I've done is I've taken the ownership of whatever asset I wanted that entity to control, and I've retitled it into the name of that trust or that entity or that business, if you want to think about it as a business. So now I don't really have title to that asset anymore. It's titled in the name of that business or that contract. That's a very important concept to keep in mind. You are divesting yourself of legal title, right? You might benefit from that asset. You might still have a beneficial ownership, but you yourself don't own it any longer. The trust owns it, and you happen to be the president of that trust, right? So, the other thing you have to worry about is, of course, as in a lot of estate planning documents, what happens if you're not able to manage that business anymore? What happens if you become incapacitated or you're temporarily incapacitated, a car accident or stroke, or you're just traveling the world and you don't really have the ability to manage that entity anymore? You want to make sure you have someone named in that trust as the vice president, right? I'm president, I'm in charge, but wow, what happens if I'm not in charge? Something happens. I need to have a vice president in place or named who's capable of, and capable is an important word, capable of handling this entity or whatever it is. So keep in mind that just like in a power of attorney, just like in a healthcare surrogate, just like in a will, you're going to need a successor who can step in and manage if and when it's necessary. So trust, there are as many different kinds of trusts as there are kinds of cars. Okay, lots of different cars and vehicles do lots of different things. Well, there are lots of different kinds of trusts that can accomplish a lot of different things. They're testamentary trusts, irrevocable trusts, special needs trusts, joint trusts, family trusts, gun trusts, pet trusts, legacy trusts, land trusts. There are all kinds of trusts. Some of them are really intended to address a specific issue, for example, pet trusts. Some people really believe in pet trusts. In my experience, and again, this is just from my experience, very often, if I have a client who has animals, pets, that's the easiest part of my job because everybody loves animals. Everybody. I mean, it's hard to not find people who will go out of their way to help animals and support. So any client that I've had who has either passed or is for whatever reason unable to manage the care of their pets, it is an easy thing to find a loving family. I don't care if it's a two-legged, blind, biting Chihuahua. There's going to be somebody out there that's going to love that pet. So with that said, I'm not sure that pet trusts are super necessary, simply because I've always been able to find a loving solution for them. So even if you have a dear friend or family member, maybe a dollar amount, a specific dollar amount to give to that person to care for the pet is all you really need. And a continuing trust is probably a little bit more than what's necessary. But they sound good, right? Pet trusts. Special needs trusts. Again, those are specifically or generally designed for people who have a disability or who are receiving government benefits of some kind. So if you have a child or a loved one who has a particular disability or disease that may be eligible for government benefits, and you don't want them to be disqualified from those, and you want their assets to fall into what's called a special needs trust. So like I said, there are a lot of complicated areas of trust. Some of them are very specifically designed for a specific purpose. It can be tax planning, legacy planning. It could be to own a second home, a vacation home with family members, etc. So today, we are just going to focus on what we typically hear about, which is the revocable living trust. That's the one we typically hear. That's the one that you're going to run into the most. So that's all I'm really going to focus on today. But please understand, there's a whole big world out there of trust. Most of you are probably not going to need that world of trust, but when you go meet with your estate planning attorney, you can talk about those options and see if one is good for you. So what are the advantages of having a trust? Well, one of the biggest advantages is control. That whole ruling from the grave that you've heard, that saying that, granddad died and he's still ruling from the grave because his trust has all kinds of restrictions in it. So a trust really does provide a person control. So I've created this entity, right? I put all my money in it. So when I die, this trust is going to control this money. And I have written out specific instructions about who gets what and how they get it, and what they must do to get it, or if they do X, they don't get it, etc. And that's called control. So a lot of people really enjoy the ability to control their wealth for multiple generations, if not just their own children and grandchildren. Very often you will see what I call behavior modification clauses in trusts. What that means is I, Darby Jones, create my trust. During my lifetime, I'm in charge. I can do whatever I want. I can spend all of it. I can add to it. But when I die, I want this trust to go on for the benefit of my 2 children. But if one of my children shows signs of drug abuse, then he shouldn't get any benefits. Or if they aren't working or generating an income, they shouldn't get any benefit. Or if they are, if they don't get a prenuptial agreement when they get married, they don't get any benefits. These kind of clauses can go on and on and on, and they're called behavior modification clauses. I'm not a big fan of these provisions because over time, they're very difficult to manage or administer. A trustee is in charge of monitoring that behavior or monitoring whether they're working or not, or whether they're taking drugs or not. And we're going to talk a little bit more about these provisions later. But those are the provisions that people utilize to control the use and distribution of their funds after their death, or behavior modification. Another benefit is for the care of surviving beneficiaries. Talked a little bit about this when I was talking about special needs trust, that if you have, let's say, for example, my spouse is showing signs of dementia, it might be a good idea for me to create a testamentary trust. In other words, a trust that comes to life after my death, not necessarily a living trust. A simple testamentary trust that will take care of my spouse if he survives me, because he's unable to manage his own affairs, clearly. So that there is a need to take care of maybe a disabled child or a disabled spouse or a loved one. That's another good benefit of a trust. There is conversations out there about how trusts will avoid probate and that it saves money because you don't have that entity or whatever you have named in that trust is now not going to go through probate, right? If y'all watch Demystifying Estate Planning and memorize my little stick figure, you'll know that this over here, anything in contracts, insurance policies, pay on death accounts, transfer on death accounts, trusts, IRAs, retirement accounts, all those assets do not go through go through probate. The only things that go through probate are things that are in your name alone at your death. My shoes, my socks, whatever else I have that's in my name alone. Now, that's not always a good thing, and we'll talk about that later, but some people view that as a super advantage to avoid probate by putting everything into this trust. Another benefit is asset protection. Sometimes, and this is not foolproof, okay, you're not going to avoid all your creditors by putting everything into a trust. But again, remember all those different kinds of cars we have out there and vehicles. There are definitely some kinds of trusts that are specifically designed to protect your assets from creditors, or to protect those assets from the creditors of your beneficiaries. So for example, my 2 kids, when I die, their money is in a trust. And if they go out and have a gambling debt, or if they go out and get in a car accident, this money may not be attached to those lawsuits or gambling debts. Now, that is not foolproof. Okay, it really depends on the state in which you live, the laws that apply to trusts. Every state has very substantial trust codes. So it would really depend on what your state law says about the asset protection benefits of trusts. But that is one of the common considered advantages of trusts. Now, again, most of the advantages we have been talking about are after your death, right? Another advantage that people perceive is that they are private. Trust documents are private. I write my Darby Jones Revocable Trust in my own, with my attorney. It's mine. I keep it in my house. Nobody knows I have it. Nobody needs to know I have it. It's not filed with any court. At my death, it's not filed. Nobody ever knows it exists, or can possibly ever know that it exists. Now, is there an advantage to that? I guess. I'm not sure that there's this deluge of people that run down to the courthouse to look at people's wills. But I guess if you're a celebrity, or if you don't want someone looking at your will, because wills are filed with the court, then yeah, I guess the privacy is a benefit. But at the same time, there could be some real disadvantages to that. Because if I've named someone as my trustee and I die, that person may not even know what to do, or they may not do anything. And so there is no supervision, no oversight about the administration of that trust. So that in some ways could be a little bit of a risk. Another advantage is that it can provide for incapacity planning. Just as I have said many, many times that in my opinion, the most important estate planning document is a power of attorney. Power of attorney naming somebody that you trust and is capable and available to step in the event that you become incapacitated. Now, again, that could be temporary, car accident, stroke, travel in the world, whatever it is, but you've got someone named in that power of attorney to help take care of your affairs. A trust will achieve the same thing for the stuff that's in the trust, right? That trustee can only step in and manage that business. They're not really going to be able to manage your personal affairs or anything that's not in the trust, just what's in that trust. So by naming that vice president, remember, that person is going to be able to manage the affairs of that trust in the event that I become incapacitated. The last advantage that I'm going to mention is that they're hard to attack. It's hard to challenge a trust. It's hard to say, hey, I don't agree with that provision because it's against, it's not what she wanted and it's not fair to me. Or the person that made it can't just cancel it. It takes some effort to terminate a trust. It takes some effort to challenge a trust. So once you create it, it's a little bit hard to unwind it. And that's a little bit of an advantage over power of attorneys. Because for example, if I sign a power of attorney and I name my son as my agent under my power of attorney, and later he marries somebody I can't stand and we get in a big fight, I can just rip up that power of attorney and name somebody new. Easy peasy. A trust is not that easy. I can't just terminate a trust or take away that vice president who I've named. I've already let go of my legal authority to do that. And if I'm incompetent, I'm not able to change that anymore. So what are the disadvantages of a trust? Disadvantages are they're expensive. You know, obviously, if you're going to go to an estate planning attorney and you're going to do your estate plan, as you know, there's 5 documents, right? Got your last will and testament, power of attorney, healthcare surrogate, living will, and possibly that trust. That trust is going to be a pretty substantial document. That's going to cost more. If you only go in with for 4 documents, it's not going to cost as much. Not that cost is a reason to want or need a trust or not, but just be aware it's going to be a more expensive estate planning package. There's also ongoing expenses to a trust. Once you create a trust, many times, depending again on the state in which you live and the trust code that controls that trust, you might have some annual accounting responsibilities, tax filing responsibilities. There might be a responsibility to appraise the assets inside that trust every year, the valuation of the items inside that trust. So there are some ongoing expenses and administrative work that needs to happen to keep that trust valid and up to date. Don't forget that you also are going to need a trustee, right? So I've created this entity, this business. I still have to be the president, right? There's work in that. I still have to step in and take care of those assets. While I'm alive, they're my assets. That's cool. But what happens when I'm not? And my vice president is now taking care of it because I now have dementia. That person needs to get paid, right? So the trustee is going to need compensation. They're going to have to do tax returns. They're going to have to do accountings. They're going to have to report to the beneficiaries. There's a lot of administrative work when you're serving as a trustee, and that's a cost. They can be complex. There might be a reason for that trustee to have to meet with your attorney or your CPA or a tax advisor or investment advisor on a regular basis to make sure the investments are being administered appropriately for your cash needs or not. And what if that person, the vice president, who may or may not even want to serve, they may say, you know what, this is more than I want to do. Now you're stuck. Now there's no one willing or named in your document. You're going to have to find a successor trustee. Another problem is, and this I see quite often, is I create the trust. I have my 2 children. I die. I name my one son as trustee over the ne'er-do-well son because I don't like who he married, right? So I have my one son is the trustee over the other son. My estate gets divided in half. Half goes outright to one son. Half goes in a trust for my other son. Well, his brother is his trustee. Now you can tell how long that's going to last, okay? Not long, because that's going to just pit those brothers against each other. And a lot of that anger and angst and acrimony is not necessarily coming from the brother, but the brother's wife. Because she's over there going, why did your mom do that? That was so mean. That's so unfair. Your brother's being horrible. This is the worst thing. So think about why do you need a trust? And is it really going to benefit the heir or the person who you're trying to protect or take care of? Think about the parties who are involved. Who is the trustee? Who's the beneficiary? Who's going to manage it? Is that really sustainable? Is it really going to work? Another, what I don't think is a disadvantage, is the avoidance of probate. I love probate, okay? Probate, the definition of probate is the court supervision of a person's will. Now, I kind of like that. I like having speed limit signs on the highway. I kind of like having the Coast Guard out there watching boaters. I kind of like having the court supervision of my will to make sure it gets done appropriately. Not a private trust over here where who knows if the person really is going to do what they're supposed to do or even distribute the assets that they're supposed to distribute because there's no oversight. There's no real court legal oversight unless something goes wrong and unless the beneficiary finds out. So yeah, I like probate. Is there a filing fee? Yes, there's a filing fee. and you're paying for the court supervision. But it also keeps the personal representative on task, because the court's going to say, hey, personal representative, we need your inventory. Oh, and by the way, you need to do an accounting, and don't forget to file the tax return. So there's a process to probate, and there's accountability. Does it cost? Of course it costs money, but it can also cost money to administer a trust. Okay. Let's say I've got my entity over here, my trust. But let's also say, in another example, I don't have a trust. Everything is in probate. Okay. In this example, I've got a house, my car, my shoes and socks, everything is in the trust. Over here, my house, my car, my shoes and socks are all in my estate. If I'm the successor trustee, I have to administer this trust. If I'm the PR of the estate, I've got to administer this estate. It's the same stuff. I still have to sell a house. I still have to sell the car. I still have to do tax returns. I still have to pay the creditors. I still have to do a lot of work. It's kind of the same work, whether it's in a trust or in an estate. It still takes time. So it's not necessarily faster or cheaper. Now, there are times where it is, okay? But in my experience, without a doubt, by a big majority of the clients that I have worked with over the last 30 years, most of the people who had trusts did not need them. They did not bring any benefit or advantage. In fact, at the end of the day, it was more work and cost more money, because very often, one of the challenges with trust is you have to put stuff in the trust, right? So how do you put stuff in a trust? We created this business. How do I put stuff in the business? Well, you have to retitle the asset. If it's land, you have to retitle the deed. If it's a bank account, you got to retitle the bank account. If it's a car, if it's an investment account, if it's a rocket ship, an RV, golf cart, whatever it is, you have to retitle it into the name of that trust. That's the kind of stuff that a lot of people don't get around to doing. Or they go through life 20, 30 years later, they've bought a new house, they've moved to a different state, they all kinds of more stuff that never made it into the trust. So at the end of the day, their will says, oh, everything I own goes into my trust. So now we've got to open up an estate and then move everything into the trust and then administer the trust. It's because they didn't fund the trust. It's a very common error and a big mistake, and it just causes, again, more work than not at the end of the day. Another disadvantage are these behavior modification. I mentioned to you a little bit about the drug provisions. Long time ago, in the 50s and 60s, drug provisions were very common. And keep in mind, when you do your estate planning, your documents may not even really be needed for another 30 years. So who knows what addictions are going to be around 20, 30 years from now, right? Back in the 50s and 60s, they were worried about gambling, alcohol, and drugs, okay? So trusts were written to say, if my child is is an alcoholic or drug addict or gambling, then they're not entitled to any benefit. But today, there's no way to understand the drug testing, because drugs today can avoid the drug testing. They don't catch synthetic drugs. And the provisions from 30 years ago just say drug test. Well, today you need to do hair samples. You need to do blood samples. And if you don't have that specific authority in that trust, you're not allowed to do them. So you're just relegated to the same old drug test, which really doesn't catch the drugs of today. The other challenge is today we have things like addiction to food, to shopping, to video games, to lots of behaviors that are far more harmful, but yet we didn't contemplate them 30, 40 years ago when we were drafting these trusts. So my point is, if you want to help your child with whatever addiction or problem that might arise, just let your trustee have that discretion. Don't try to figure out what it's going to be and punish them. Give that trustee the discretion to take care of that problem, whatever it might be 30, 40, 50 years from now. Tell them that they're allowed to hire a professional to manage that addiction or affliction or whatever it is that might arise in the future. So I'm not a big fan of the behavior modification. And then finally, the disadvantages, is it really needed? Do you really, really need a trust? Do you think are you getting talked into it because of the television ads or every estate planning attorney talks about avoiding probate and it's cheaper and it's private and it's quicker? Don't talk yourself into it unless you really need it. A solid power of attorney is a very important document, and it can achieve many of the same things, although they do have their disadvantages as well. And the downside to power of attorneys, of course, is they can be canceled. I can revoke a power of attorney very easily. It's not as easy for me to revoke a trustee who's now serving. So how do you we talked about putting things into a trust and how you retitle the assets into the trust, which is a challenge. And we talked about the challenge of the ongoing management of the trust. But let me give you a little story about what I tell people when I get asked, well, I have a will, do I really need a trust? Or I have a trust, do I really need a will? And I don't have a lot of money. Trusts are really just for people with a lot of money. So I don't need a trust. Let me give you an example of when a trust is really needed, and it doesn't have anything to do with wealth. We've got down here in Florida, and probably everywhere now, we have a grocery store chain called Publix, right? I don't know what chain you guys have where you are, but we have Publix. And let's say we have a young lady who's working as a cashier at Publix. As part of her employment benefit, she has a $100,000 life insurance policy on her life for her children. Her child has cerebral palsy. She's living paycheck to paycheck. Now, does she need a trust? Yes, she needs a trust. She doesn't need a revocable living trust, but what she needs is what's called a testamentary trust. And those of all the trusts, those are the ones that I prefer because it's part of the will. It says in my probate will, says, here's my estate. Take this amount of money out of my estate and put it into a trust for the benefit of my child. Or put it in a trust for the benefit of my surviving spouse. Or for whoever it is that you need to care for at your death. Because during her lifetime, she didn't have any money. That life insurance is only there at her death. So she really didn't need a revocable living trust. All she needed was a small testamentary trust to take care of that person who may survive her at her death. Those, I think, are incredibly useful. And they don't have that ongoing administrative challenge that we have. Now, sometimes it is about the money. Sometimes it is about wealth. Remember all those cars we talked about, all the different kinds of vehicles and different performances. There are trusts who are designed for people with wealth, for tax planning, or perhaps a vacation home to provide a structure on how to manage that house at the death of one of the family members so that everybody is treated equally. That may or may not be able to be accomplished through an LLC as well. Not necessarily just a trust that can accomplish that. But there are a lot of high net worth trusts that are valuable and do provide a really important service. But it's really at the end of the day, very often it's about control and people who really want to control their assets after their death. And then you have to kind of think, is it worth it? Is my And I'm a control freak, just like most of us. But is it worth it really? Very often the value of the trust is almost not worth having the trust. People call me often and ask if I'm willing to serve as their trustee if they are not able to serve. And my kind of average response is, if it's not $400,000 or $500,000, it's probably not worth it. It's just too expensive to pay me to be the trustee and to manage those assets for someone. So think about what the value is, whether it's really needed or not. Is it worth it? And to keep for generations and generations, and it just goes down in value over the time until it's really more expensive to manage it than it is to not. Now, a lot of what we talked about, and I haven't had a chance to read the chat. I'm almost scared to look at it, but keep in mind that you can probably guess that I'm not a huge fan of trusts. I can see their benefit, and they do have advantages. But just from my experience in dealing with my clientele, more often than not, they were really not necessary. And you all need to think about why you want to trust and contemplate that with your attorney. That's what your attorney is paid for, is to talk through these issues with you and to determine whether it is or isn't something that's necessary for you. If you're young and you have young children, you might want to think about, who's going to care for those children at your death. That could be a good reason to maybe consider a testamentary trust. Blended families, there's some issues there. I'm married to a guy, he's got kids, I've got kids. We're all wondering who's going to die first, who's going to, make the money grab. So estate planning and trusts are very valuable in that situation as well. In fact, I think that's a lot of the reason why some of those families don't get their estate planning done, because that conversation can be really tough. But blended families, that's probably a good place to think about trusts as well. The vacation home we talked about, if there's a unique business, let's say I owned a beauty parlor, okay? My two sons don't know anything about beauty parlors. So, and I've got a lady who's been working there for 40 years, and I want her to continue to be able to work. So maybe I put that beauty parlor in a trust and let that be managed separately, because my kids are not going to be qualified or capable of managing a beauty parlor. That's actually pretty funny to think about. And then you've got the disability issue. Okay, so if you have a child with cerebral palsy, or if you've got a husband who is, experiencing some dementia, those are also reasons to really consider having a trust, or like I said, a testamentary trust. So if after everything we've talked about, here are some general concepts or concerns and drafting suggestions that I have for you. Number one, ask why you want to trust. Is it worth the cost? Is the control, is the juice worth the squeeze, so to speak? And Erica Roothouse, who is an attorney in my area, she's excellent at this. One of the things we like to see in trusts is what's called a statement of intent. And this is something you yourself write down in your own words, why you want that trust. I want this trust because I had a trust from my father, and it was used as just a safety net, not an income replacement, not meant to be used haphazardly. And I want my trustee to only make distributions if it's reasonable and necessary. In your own words. That way, 30 years from now, when your trustee is getting that 15th phone call from your child asking for yet another car, they can pull out that trust and read that sentence, and they're going to recognize your voice. They're going to hear you, and that's going to make that trustee's job so much easier, because They're always going to want money. That's one of the jobs of a beneficiary, apparently. Also, instruct your trustee to have the authority to hire professional help. Again, let's say I've got 2 kids, right? I die. My one son is in charge of his brother. He's so afraid to spend money because he knows that I would want him to save everything for the benefit of the brother. But he doesn't know what he's doing. He's not really sure about the taxes, but he's so afraid to spend anything. So give him the permission, put it in the trust that my trustee has the authority to hire professionals, to hire counsel, to hire advice, to hire a caseworker, to hire anybody that's necessary to help that person be able to be successful as a trustee. Because being a trustee can be very challenging. I would also highly recommend avoiding behavior modification. Avoid the drug addiction, all that stuff. Just give the trustee the authority and the discretion to deal with whatever life challenges come along for your beneficiary. Now, I'm going to stop here. I'm going to tell you again what your 5 documents are in your estate plan. And then Chandra, I'm going to ask you to help me with some of the questions that have rolled in. But remember, there's a last will and testament, power of attorney, the most important one. I should always use that finger for power of attorney. Healthcare surrogate, and living will, and possibly a trust. Okay. I hope your brains aren't exploding, but it was difficult to put all this down in just a 45-minute presentation. So, okay, let's have it.
All right. Can you speak about a living trust with a pour over will, or a pour over will into a living trust?
Yes. In fact, if you have a living trust, your will is a pour over will. And what that is, okay, I've got stuff over here in my own name, right? I've got a car, maybe my shoes and socks. I might have a CD at a bank, a couple other things. And then I have this trust over here where I've put a lot of my assets. Well, I die, right? So this stuff has got to get into the trust. So my will is going to be what they call a pour over will. It's going to say, hey, whatever's out there that I didn't get put into my trust, put it into my trust, transfer it into the trust, so that the trust is the controlling document on how to distribute your estate, not the will. It's just pouring through right into the trust.
Can you have 2 vice presidents of your company?
Yes, you can. I don't recommend it because they probably won't get along and never agree to anything. But you can. I don't recommend it. I would highly recommend having successor vice presidents. So I guess first, second vice president. So you have one person named as your successor. If that person is unwilling or unable, then a successor would be my recommendation.
Can you put a safety deposit box in a trust?
Actually, that would depend on the bank. I doubt it because a safe deposit box is something you're leasing. You're leasing that safe deposit box from the bank. You don't actually own it. You're signing a lease. So that would really depend on the bank and whether they will allow you to put it in the name of the trust.
Another question about the VP. I should have lumped these together. I'll make this a 2-part question. First part, can you name one of your children as the VP of your trust? And who would you advise to be the VP if you don't want your family to be it?
Well, you can't. Of course, you can name your child as long as they're over 18 and competent and capable and willing and able and trustworthy and all that other good stuff. Yes, you can name your children. If you don't have anyone, that's where someone like me, a professional fiduciary, or you can talk to your attorney about individuals that may be able or willing to serve. You can also talk to trust companies, what used to be called trust officers. I used to be one. And you would get a corporate trustee to serve in that capacity. I'm probably more in favor of having an individual, but a corporate trustee is not a terrible choice either. There are a lot of local trust companies, I'd recommend you search out a local company as opposed to a national chain. That way you're not really having to call an 800 number. Sometimes it depends on the size of the trust and the complexity of the trust as to who might make a good successor trustee. But reach out to your attorney or CPA or someone who might have a recommendation, or a professional fiduciary like myself.
And this is a little bit more of a legal question, but I think that you can just give us a ballpark or recommend who to talk to. Do trusts help with Medicaid planning?
Medicaid and not Medicare, Medicaid planning is really an elder law issue. As a matter of fact, last month's episode was all about elder law. So whoever asked that question, I highly recommend that you go to YouTube and look for, or the agingacademy.com, and look for last month's episode, and that will answer your question. But yes, there are trusts that are utilized in the process of applying for Medicaid.
Right. And I think someone else answered the question here. What is the name of the trust to put money into for your child from your will? And someone said it was testamentary.
Yeah, and the will is called a testamentary trust. Back in the good old days, that's a lot of what you saw, and they were great because it doesn't take any kind of work or administrative challenges while you're alive. It's in your will, and so it doesn't come to life until your death, which in many ways is a good tool.
Is a trust appropriate for an orphaned adult?
Well, it depends. I don't, if you have a solid power of attorney in place, and when I say that, I mean you've got someone named and a successor, right? You've got your sister, your brother, your husband, your son, whoever, and a successor named in your power of attorney, that can accomplish pretty much the same thing as the trustee would have accomplished. So if you have a solid power of attorney, naming a person you trust and are available and competent, you're good to go.
Oh, this is interesting. We do not know how expensive college will be 10 or 15 years from now. Grandchildren and grandnieces will probably need financial aid. Will a trust affect these children from receiving financial aid?
Well, back in the good old, well, God,
I know.
back in the good old, I'm definitely getting there. There are things called 529 plans, and there are also things called crummy trusts. In fact, I probably should have added that to the list. Those are very common for grandparents to create for grandchildren, and not necessarily just for education, but is primarily geared for that. And that is a tool. So you again, talk to your estate planning attorney about trust specifically for your grandchildren's education. Now, whether the university or college where they're going to ask for that information is another story, but generally speaking, it should be helpful.
Can you repeat again your 5 things?
Last will and testament, power of attorney, healthcare surrogate, living will, and possibly a trust.
It's like the little piggies, and this little one is just a maybe.
Yep.
How do you help? My brother is a successor trustee and now has FTD, I don't know if that's FTD dementia. How do I take him off the trust?
Well, is it your trust? And if he's named in your trust, you can amend it anytime you want. If this is your trust and he's the third trustee, you can simply amend it and remove him and name someone else. That's not a problem at all.
If the bank doesn't allow safe deposit boxes to be titled in the trust, how does the trustee access the contents?
That is a very good question. And they can't.
Oh, well.
A trustee is only allowed to manage or have access or authority over what's in that trust, right? what I've put in that trust. If the safe deposit box isn't in there, they don't have authority over it.
Oh, my goodness. All right, that's another topic for another day. Safety deposit boxes. Who
You can,
knew?
you can get with the bank about it, but it,
I want to give my co-op to my son. Would you recommend creating a trust for the co-op?
I'm sorry, say that again.
I want to leave my co-op to my son. Would you recommend creating a trust for a co-op?
Well, again, it's very difficult to answer something like that
I
specific
know.
situation because there could be so many other reasons to or not to do that. So I would definitely talk to your estate planning attorney. It depends on some, maybe the different states or different tax situation or different titling issues. Co-ops have their own probably bundle of regulations about who can inherit or not. But again, is it worth it? Why not just let him have it? I mean, if he's going to inherit it, let him inherit it. Unless there's a reason not to. So again, I don't know that I can answer that fully. I apologize for that, but that's a good conversation to have with your estate planning attorney.
This
Not the
is a
internet,
little,
not the internet, not the
don't
internet.
use Chat GPT for these questions.
And, and,
Do not
and,
use.
and I do want to say that too. This is the reason why online DIY estate planning is just not a good idea, guys. Okay. We spend a lot of time trying to figure out what kind of shoes to buy or what, bed linens to buy. Your estate planning deserves time and expense. You want to make sure you get it right, and you want to meet with someone who's qualified and competent and capable of answering your questions honestly and get that consultation. Okay.
Yeah. Wow, these questions just keep pouring out in. Um, this is a little different. Is a trust advisable for my LLC with 5 rental properties?
Woohoo. Okay. That sounds kind of along the same line as a co-op. You may not necessarily need the trust, but you might. Again, it's that if you've got 5 rental properties, you're smart to have them in LLCs. That's really smart because you've done your liability protection that way. So I would sit down with your estate planning attorney and ask that question. If there's some particular reason for you to add that layer of administration around them, there could be some good reasons for it.
This is something that some folks may run into. So I'm gonna. My father got mad at his trustee friend and told the trustee that he changed the trustee to my brother. However, no paperwork is filed that anyone knows of, and my brother didn't even know about it. The trustee told me. What should you do about this? Who do you call? Not the Ghostbusters. Who do you call in this situation?
Well, that's exactly one of the challenges with trusts. There is no real depository for them or any reporting requirements. And sometimes some states don't even require that you notify the beneficiaries that they're a beneficiary of a trust. So that's one of the challenges. I would, I wasn't sure I followed the story exactly right, but if you're worried about whether you're named in a trust or someone's named in a trust, I would go consult with an attorney and see if you might be able to request or demand some information from that trustee. That in Florida, we have substantial requirements for trustees, reporting requirements, disclosure requirements, notice requirements. So a beneficiary clearly is aware of the existence of trust. So in your state, you may have a statute like that. So see if there's one out there.
I was just trying to see. I missed one question. I was trying to go back to it. Let's see. I know you may have answered this before. The recommendation for someone never married, no kids. Professional fiduciary is a good suggestion.
Now here's,
Um,
I have a revocable trust as well as a will. I put my home in the trust so it wouldn't have to go through probate. Are you saying that the will would have been sufficient instead of paying for more trust? In my opinion, again, not knowing anything else about your situation, yes, your will could have just left your house to your son. That's simple. I'm not entirely sure what the reasoning behind that was, but,
The reasoning was to avoid probate, paying the probate fees, because I was told there's a percentage that they do on a home in order to
Well-
pay for. I figured that would have been more costly.
well, it would depend on the value, value of your home, value of the negligible probate that would have had to happen. So you can also in Florida do a ladybird deed where you have the deed go directly to your son at your death, almost like a pay on death account where you wouldn't have needed a trust at all. And it would have avoided probate.
Okay, great, thank you.
But again, avoiding probate is not avoiding the cost of negligible costs of administering an estate. It's not a reason to jump to a trust. It may be, again, those are why you want to consult with your attorney, but it may not be. So goodness, we have a lot of questions and we are up at 2:00.
I know. So I just want to remind everyone before I let you go from today, I'm going to copy these chat questions for Darby so she can read through them all, because I think it will really help her in looking at future episodes. We had some requests for things in there, so we're going to make sure we take care of that. I do want to remind all of you that you will receive an email later today with a survey. Please, please, please respond to that. AARP really wants to hear from you and how these sessions are helping you in navigating these tough decisions. So please fill that out. Yes, Darby?
And next episode is your financial future safe? And what we're going to talk about is how to make informed decisions and safeguard your assets. And we're going to have a conversation about crypto. I'm going to have an expert guest speaker as well. So hopefully we'll see you next month, and I'll have my shelves populated again. I'm still waiting for hurricane permits to be able to get my office moved back in. So I apologize for the background. And again, thank you all so much for everything. I really enjoy all of this.
Thank you all. Have a wonderful day, and we'll see you next month, third Thursday at 1 o'clock, May 15th. Be well, be safe. We'll see you soon. Bye-bye.